the workshop under our project, Medimare, Mediation in Maritime Disputes. From today, we have the pleasure of hosting not one, but two communications coming from Italy, which is also, I think it's a first for our workshops, and it's a pleasure. I will present shortly our two lecturers for today. First, we will start with a communication on maritime mediation in shipping, a practical insight by CARLO CORCIONE. CARLO CORCIONE is a lawyer and a consultant specialized in international trade, shipping, and logistics. And we have been talking about this a little bit before this workshop started, and he also told us about his very proficuous and international career as an adjunct professor in the field of undergraduate, master, and doctoral students courses at Italian and foreign universities, with also, we highlighted this, lots of international reach in terms of students. The subjects CARLO CORCIONE teaches are related to navigation and transport law, sustainable mobility, shipping finance, logistics, new technologies and electronic commerce, and research methodologies. I think all of this knowledge brought together and binded here in one person will for sure enrich our discussions on maritime mediation. Afterwards, Giovanni Matteucci will hold a communication on an issue that we've been sometimes talking about, but not developing a lot, which is the Singapore Convention and also contractual clauses. It's a very hot topic today, and Giovanni Matteucci will for sure deal with this wonderfully. He's a civil mediator certified by the Italian Ministry of Justice since 2006 and a trainer since 2011. Of course, as a mediator, he operates not only in a location, he's a mediator at the ADRCenter in Italy, MHJMC Mainland-Hong Kong Joint Mediation Center, and KIMC Korea International Mediation Center. So you can see that this is Giovanni will bring to the table a very rich experience, mostly in countries where mediation is more developed than in others, as in Portugal. So he wants me to be light on the compliments. Let's keep them for later, right, Giovanni?
My subject is banking and finance. This is my subject, okay?
Indeed, you are also an advisor in over-indebtedness proceedings, and then this is the field where you most work and also probably exercise the other activities that you have. So it's a pleasure. We have been already presenting ourselves before, so I will just give the floor to Professor CARLO CORCIONE to start his presentation. And then we will continue with Giovanni Matteucci's presentation. Do you have a PowerPoint to present? You do?
Yes.
So I will co-host you.
Let me quickly put it on.
Perfect.
Do you see it?
Yeah, it's perfect, even in the format. So
and do you see moving the slides?
Yes. Yes.
Okay, perfect. Thank you.
Works perfectly. So
okay, thank you very much for having me at this delightful event. Thanks to Roberta for the wonderful organization of the event. And today, since we are in the topic of mediation, and I have practiced quite a lot in the practical aspects of mediation in the shipping, I decided to turn my presentation into a practical insight. And I must say, mediation is practical itself. I find very pointless sometimes to argue in courts for 10, 20 years when we can cut it off and get some good results from our perspective with a good mediation. I've got several experiences in this field, both from contractual type of claims reaching a mediation stage, but also from casualties. I've had a few mediation coming from piracy attack, for example, in the shipping industry. I had one vessel, I managed a vessel under piracy attack for 11 months in 2011 in Somalia. And I have managed the whole procedure after the piracy attack for the general average of the vessel and the mediation process that was the final stage, as well as another famous case of mine is the Maroc case, the two army guys that were involved in the big accident in Indian waters. I don't know if you remember, but there were a lot of political involvement there, and that was another vessel of mine. And the process after the case itself reached a mediation level with our counterpart. After this brief introduction, let me say that the presentation of today is what I call a funnel methodology presentation, because since it is quite a niche topic, I'd like to introduce you to dig into the factual context of the shipping industry. Otherwise, the mediation process will be a little bit pending. So first of all, we need to get ourselves in the factual context of the shipping industry to understand where the problem arrives from. And then the second point is what we mediate out of this word. And the third point is why we decide to mediate. So without further ado, let me start with the first aspect, which is the factual context of the shipping industry very, very quickly, especially for those who are not particularly familiar with the topic. Shipping, when we say shipping, it's simply the transportation of goods from point A to point B, following an international sale between two subjects. The example I make the most is the soybean. Soybean are produced in South America, but let's say majority of consumer of soybeans is Asia. And we simply put these 2 points together. We get soybeans from South America and we bring soybeans to Asia. This is essentially shipping in a very brutal word. So effectively, all we do is matching supply and demand around the world. When we say shipping, we mean cargo vessels very effectively. Containers, dry, liquid, offshore vessels, very niche topic like livestock and these sort of things. And they all have specific claims that arise from different aspects and different contracts. And they are all part, of course, of the procedural steps that might reach a mediation stage. Just to give you an idea on how many claims we might have in this industry, just think that 90% of the world's transportation is by sea. Whatever we buy, effectively 9 out of 10 at one point in their leg pass a sea step. Our iPhone cover, our Prada bag, our grain, our coal, our oil, everything comes by sea. So you can imagine that in absolute terms, 90% of the world's transportation by sea means a lot of claims and so a lot of opportunities for mediation. At the moment, on water, there are 55,000 merchant vessels, so cargo vessels in the world, all bringing a lot of problems, of course, and 8 billion tons of cargo are transported per year by sea. Effectively, the fundamentals of this industry are supply and demand and macroeconomics. Very briefly, macroeconomics, the Suez Canal gets stuck for an accident, the war between Ukraine and Russia, China that decide to pull the plug for a couple of years and not import that much, and so on and so forth. You can name all the macroeconomics aspects. And the supply and demand is the balance between the cargo that is available and the order book of the vessel, so the vessel at sea. When these two fundamentals change, the market change completely. This is just for you to look at, is a graph of, is a chart of dry cargo vessels. I don't want you to focus on the chart itself. I want you to look at 2008 peak. If you look at 2008, the peak means that a dry cargo vessel, the vessel that brings the grain around the world, was making $150,000 per day. $150,000 per day. When I make this example, I always say to people that at that time, we were winning the lottery every day of our life. We were waking up and winning the lottery every day. And look what happened 6 months later. The world collapsed, the subprime crisis in the United States, the bank pulled the plug, and the world completely changed. So the same vessel passed from $150,000 per day to $5,000 per day. Why I'm showing you this? Because in these 6 months, all the contracts for that specific type of vessels, shipbuilding contracts, time charter for chartering the vessel, transportation contract to transport the cargo, they all needed to be restructured. They were all in a default position just because the world outside us were changing. And all these contracts, of course, were claimed at court, and majority of this contract were finally mediated in some way, negotiated or mediated in some way. So the shipping world is a really volatile world. These are all the aspects that might bring claims and mediation. First of all, if we want to work in a shipping industry, we need to buy a vessel. And if we need to buy a vessel, we need to go to an Asian shipyard. Japan, China, and Korea are the major countries for vessels. And in my experience, the claims for shipbuilding contracts are the most expensive claim in this industry. And so they are worth at one point being mediated instead of being fought in court for 10 years or so. Then we have second-hand sale and purchase market, which is the same we use for our cars. When we want to buy a vessel second-hand, we go on the second-hand sale and purchase market. Less expensive type of claims, but of course, most often we can have problem in a closing for sale and purchase market. So again, this might go to a court, an arbitration, and finally reaching a mediating state. Time charter means chartering a vessel for a long period of time, I don't know, 5 years, 10 years. So imagine how complicated is the life between a ship owner and a charterer for 5 or 10 years. There are a lot of problems every day, and all these problems need to be negotiated. And if this problem reach a point where the parties cannot negotiate it anymore to each other, they need to go to a third person, which might be an arbitrator or maybe a mediator or a court type of procedure. Voyage charter on the spot means bringing cargo from one part of the world and moving to another part of the world. Again, you can imagine how many cargo claims are around the world. At the moment, as we speak, I have 10, 20 cargo claims in Bangladesh, Brazil, China, and so on and so forth. Very important when we talk about mediation, we need to talk about who we are fighting against in court or in our cases. If we are talking about big corporations like the oil major, like Shell, BP, Chevron, Exxon, our negotiation power is very limited because they are much bigger than us, essentially. So when I act for clients against these big companies, and at the moment, as we speak, I have a big claim, by the way, Roberta, against Petrobras in Brazil, the state company, the oil state company, for $25 million. We tried a conciliation, which is the mediation in court, but there was no way to mediate. So Petrobras decided to fight the claim until the end. Thanks God, we won the first instance, we won the appeal, and now we are at Superior Justice Court in Brasilia to wait our third instance. So it all depends about our counterparty. If we are talking about, a trader in the grain or the soy, might be easier to mediate than a state company, because state company usually don't go to mediation because no one really take the responsibility to take a settlement. They prefer to fight until the end and pay if they lose, very, very, very briefly. Again, offshore is the same because we are talking about oil companies. And then, apart from all the contractual aspects in the shipping industry, you might have problems coming from the sea. As I said before, one of the major problems of the shipping industry, especially in the past, now is a little bit better, was the piracy case. In 2011, when I had one of my vessel, the vessel I was managing under piracy attack, there were 300 attacks per year in Somali waters. All these attacks and all these hijacking were reaching an arbitration point between the parties, the ship owner, the charterer, the cargo owner, etc., etc. And most of them, at one point, turned into a mediation scheme. This is what I did with my vessel. It took me exactly 9 years. In fact, I finished in 2020, and we had the whole general leverage process after the piracy attack, the arbitration, then we turned into mediation, and we finally settled the claim in mediation in 2020. But we might have a problem arising from finance, for example. If my counterpart stop paying me because there is a big crisis, and then I have a financial problem, and I might have to fight for getting my money back, essentially, for my clients. And again, this is one of the aspects that might bring cases in court or arbitration or mediation. Might be collisions, so things really outside the contractual sphere. Collisions are very popular, unfortunately, in the shipping industry, especially in Asian ports, because they are very crowded. And therefore, it's quite normal. Don't expect big collision. A collision, sometimes it's simply two vessels touching each other, which is, it's called a kiss between two vessels. But a kiss between two vessels might bring a big claim with a lot of money, because one of these vessels might cost several million, up to $150 million. So imagine a kiss, how much claim can bring. So after the factual context that I hope I gave you, let me move into the second aspect of my presentation, which is the summary of what we actually mediate in the shipping industry. We mediate two types of claims, what is called wet maritime claims, and wet give you the idea. The wet means that they are not coming from contract, but they are coming from the sea, the wet part of the sea. Collision, as I said, general leverage, which is the process after a piracy case, for example, to get your money back. A salvage, imagine to have to operate a salvage for a vessel which is in a difficult condition for the rough sea, or a salvage of a vessel that needs to support some people on sea coming from North Africa, for example, the immigrants, or marine pollution, these sort of things that are not coming from a contract. And then the second type of claims, which we call dry, because they are coming from contract, the cargo claims between us and the cargo owner, the charter party disputes between ship owner and cargo owner, the shipbuilding contracts between the ship owner and the shipyard. As I said, these are definitely the most expensive type of claims. The ship repair, the hull damage of the vessel, the bunker disputes, crew, passenger, stowaways, shore workers, so on and so forth. There are many. And finally, let me move in the last 10 minutes, perhaps, in the third part of the presentation, why we mediate, why mediation is better than fighting a claim. because there is something in our industry which is called, as all the industry in the world, that is risk. All we do in our life in shipping is managing risk. And risk, there are several definitions of risk, but the most simple one, the one I like most, is that the risk is the percentage that something negative happened and its consequence. When we go to court and we fight a claim, there is always a percentage that we might lose the claim, always. And therefore we enter into a sort of risk management. As a lawyer, I always look at the claim itself and I can say, okay, we have good chances to win, but that is a legal aspect. But then I have to move into risk management. What happens if I don't win? What are the external circumstances that can make me losing? For example, in Brazil, In Brazil, I'm fighting against Petrobras in a Brazilian court. So I'm fighting against the oil state company at home, at their home, so away in a Brazilian court. Imagine how difficult is winning that type of claim. Of course, if I had the opportunity to mediate, I would definitely have gone to mediation, but unfortunately, Petrobras didn't want. Risk management is done in 4 different ways. Avoidance, so I don't move, so I don't incur in any risk. Retention, which I retain all the risk. And the 2 effective risk management tools that we have is controlling through contracts and transferring to someone else. So all we can do in our life is trying to control the risk if there is a contract, or transferring the risk to someone else if the contract goes wrong, or if the problem comes from something outside the contract, like collision, piracy, etc., etc. And why it's so important in the shipping industry? Because everything is paid by the insurance. Our insurance are the main actor of our industry, especially the P&I clubs, which are the insurance of the shipping industry effectively. There are only 13 in third-party insurance. Actually, nowadays 12, because 2 of them, as we speak, are merging. And they pay everything. They even pay the lawyers. They even pay the legal fees. So when I have a claim in front of me, not only I have to see if that claim makes sense or not, but I have to speak with my insurer, because in the end of the day, all the decision I have to make with the insurer. So it's not only me deciding, and insurance usually is likely to go to a mediation process in order not to have the legal cost arising that much. So moving into the final mediation sphere, mediation, we know, is not a modern institution. There are many historical cases of mediation, but in shipping, this sort of tool arrived more or less 50 years ago for the overloading procedure of the courts, and it goes within, Professor Matteucci will tell us better perhaps, but it goes usually, not only in shipping, into what we call the alternative dispute resolution methods, which usually are arbitration, mediation, negotiation, and conciliation. Negotiation, what I do every day to try not to go into any procedure. If I don't make, usually there is a court, there might be a court procedure where conciliation is the first step, as it happened in Brazil with Petrobras, didn't go well. If we go into another direction, which is arbitration or mediation, it means that might be a clause in the contract that allow you to go into arbitration and mediation. I must say that arbitration is still the most used procedure in shipping, but mediation is increased. And I don't think it's a substitute, because technically what we do is starting an arbitration, exchanging the pleadings, exchanging the submission in order to have the argument and the counter argument in front of us. And only then, when we know the pros and cons of our claim, we turn into mediation. So it's not, I don't think it's a substitute, it's mediation of arbitration. It's more something that complete sometimes an arbitration process. You start with arbitration and then you turn into mediation. But when we can have mediation? We can have mediation if the parties agree to have a recourse in mediation, or if we are requested by the court, or if that case is imposed by law. The main feature of mediation is, first of all, needs to be confidential in their terms, need to be voluntary, is not judgmental, is not binding until, of course, parties don't close, is neutral, the mediator is neutral, he has some authority, and of course, as anything else, he has a time limitation to be reached. The steps of mediation in our industry, very pragmatic. First of all, there is the preparation before the mediation process starts. And I believe that arbitration is actually part of the mediation preparation. Because as I said before, we sometimes go into arbitration knowing already that after the argument and counter-argument, we will move into mediation. Then there is the opening session where the mediator briefly explains to both parties the issues and the pros and cons between the two parties. Then we go into separate rooms. This is actually how it happens in my cases. We go into two separate rooms, and the mediator starts a sort of pinpoint, come to one room and the other room, trying to convince both parties to make an agreement. And my experience here is that you need to follow the mediator, but you also need to follow your gut feeling, your instinct. Once I remember I had a mediation for a case, and I was the receiving party, and my claim was for $3 million. And so counterpart was starting from zero. So we had a mediation where the counterpart wanted to offer zero, and I wanted the whole amount, $3 million. And we were in the exploration phase where the mediator was coming to me and was coming to the other lawyer. And then at one point, the other party made an offer of 1 million. So crazily, it went from 0 to 1 million because he thought, okay, let's close very quickly. And the mediator came to me and said, if you move down to 2 million, in half an hour, we are at home with our with our mediation contract in our hands. But I said, no, I can offer 2.9 million. So I moved down only of $100,000. So my counterpart moved up of 1 million, and I moved out only of $100,000. It was a very risky move. The mediator went back to the other party to tell him what I was telling him. And he came back to me 30 seconds later, and he said, the counterpart wants to know if you're a serious person or he needs to go home immediately and mediation is over. So I moved down a little bit to 2.5. So at that point, it was up to 1 million. I was down to 500. And then that risky move at the beginning made me winning the mediation of $500,000 in the end. So it was a risky move at the beginning. The counterpart was about to leave the room, but in the end, I made $500,000 more for my client. So sometimes I think you need to bring your gut feeling and risk a little bit. And then we have the negotiation or bargaining phase, where at one point, the mediator realized that the two positions are very close. So you are moved in the same room together, and you need to close the final price together. And that is all about personal feeling and relationship, I believe. And that's why I put you a picture of a tie, because this really happened to me. I was in the final stage with my counterpart in another mediation procedure, and he looked at me. I had a tie, a Napolitan tie. I always wear Napolitan tie. And he looked at me and said, I like your tie. I have a similar tie because 2 years ago, I went to Naples and I bought a tie like yours. And I said, you like mine? And he said, yes. And I pulled the tie off and I gave it to him. And I said, this is yours. This is a present for you. So we can close it nicely as a friend. And I don't know if it was a coincidence, but from that moment on, everything went smooth. And we had a very final closing mediation without any issue. So I think in that stage, it's very important to bring some personal touch to the table. And then once you agree the final settlement price, you can move to the closing documentation. So finally, the mediator role is very important. You really need to lead the parties to find solutions, not conflicts. He needs to change the storytelling a little bit to make you understand that you might win, but you might also lose. He needs to underline the interest and clarifying the technical issues. So actually the mediation, I think the mediator needs to be a technical person and then a negotiator. And then of course needs to helping the communication between the parties and make all the parties comfortable to reach the best outcome for both. Thank you very much.
Thank you very much. This was, wow, this was really a flash review on mediation in shipping and everything that is important in just half an hour. It was impressive. This just shows that you have indeed more than all the knowledge and experience, because
Thank you.
only this allows to do good summaries, right? So it was really impressive. So I don't know. Paulo seemed to raise the hand, but probably it was a mistake, right, Paulo? So we will move on immediately after this great presentation to Giovanni Matteucci presentation on the Singapore Convention that maybe will deal with some issues that weren't yet. Well, indeed, we'll deal with some issues that weren't out under the presentation of Professor Carlo Corcione, which also involves the matter of giving execution recognition and further enforcement to mediation agreements. So it's a good complement to our first presentation. So Giovanni, if you may, the floor is yours. Do you cannot hear you? Do you have a presentation, Giovanni?
Okay, just a few words about the history in maritime disputes. Have a look at the history of the Venetian shipyard in Venice. Extremely interesting. Just about over 5-6 centuries. There are a lot of very interesting sites. The shipyards in Venice. It's okay.
Okay, perfect. Thank you for the indication.
The Singapore Convention on Mediation. Question. A Portuguese maritime operator has a branch office in Singapore, which has a dispute with a customer in Saudi Arabia. How to solve the problem? There are 4 alternatives to manage conflicts: negotiation, mediation, arbitration, litigation. In negotiation, the conflicting parties try to find a solution by themselves. In mediation, a neutral third party facilitated the communication among the disputing parties, but does have the power to impose a solution. In arbitration, a private judge chosen by the conflicting parties finds and imposes a solution. In litigation, a public court finds and imposes a solution. There is a problem in international disputes: the enforceability of the solution. In other words, how to compel the other party to comply. A judgment of a court in which it's usually enforceable in the country in which it was used may not be recognized in other state. It is significantly more difficult in relation to an agreement reached among private parties. Rules for the recognition and enforcement of a foreign judgment in civil and commercial matters of international litigation are laid down by the Hague Convention. The rules for international arbitration are written in the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, better known as the New York Convention, signed in New York in 1958, and in the ADRCenter Model Law on International Commercial Arbitration, 1985. International arbitration gained momentum thanks to the confidentiality and flexibility of arbitration, the underlying nature of the arbitration proceedings, and the enforceability of the arbitration awards. The conciliation rules were approved in 1980, and the model law on international commercial conciliation in 2002 by ADRCenter. In this disputes where time is money or is necessary to maintain ongoing business relationships, the conciliation mediation, that words are almost interchangeable, procedure, started to be used more and more often, even if they still have a long way to go. They are confidential, very flexible, quick, and cheap. But until 2019, the enforceability of the mediation agreements was not guaranteed. Just a few words about conciliation mediation. At the beginning, conciliation was used. Later on, started also to be used in mediation. In Italy, there is no difference. International framework, mediation when the agreement is reached just by the parties, and conciliation when the third party, the neutral, can just suggest a solution. And this difference is very much used in the Asian countries. But according to the United Nations, now the two words are almost interchangeable. But we have to have a look at the cultural differences of the conflicting parties. In 2014, the United Nations Commission considered a proposal by the USA to undertake a preparatory work for a convention on the enforceability of international commercial conciliation settlement agreements. In 2018, the United Nations General Assembly adopted the Resolution 73/199 Model Law on International Commercial Mediation and International Settlement Agreements resulting from mediation, including consistent standards on the cross-border enforcement of international settlement agreements resulting from mediation. The convention was signed in Singapore in 2019 and was named Singapore Convention on Mediation, LCM. 46 countries signed it, including the USA, China, India, South Korea, and Saudi Arabia. Russia, Japan, and the European Union did not sign it. The Singapore Convention on Mediation entered into force in 26 months after 3 states ratified it. Up to now, there are more than 50 countries who signed it. If I remember well, 54, 56, and 11 countries ratified it. Very important, just beginning this month, United Kingdom undersigned the convention, and is very I think that they want to ratify it in a very short time. I think that after the ratified by United Kingdom, many very important international countries will join the Singapore Convention on Mediation, and I think it will up. A quick aside at the main principles in the CCM. The meaning of international commercial mediation. Mediation, we already told about it. Commercial disputes related to commercial trade and financial operations. They are excluded disputes where one of the parties is a consumer or an employee. They may have unequal bargaining power. Or disputes related to personal, family, and inheritance matter. International, this is very important. At least 2 parties to the settlement agreement have their places of business in different states. Or the state in which the parties of the settlement agreement have their places of business is different from either. Or the state in which a substantial part of the obligations under the settlement agreement is performed, or the state with which the subject matter of the settlement agreement is most closely connected. There are a lot of opportunities, and I think that there will be many differences in understanding them. Agreement may be recorded in any formal writing, electronic form included, signed by the parties and the mediator, with a certificate by the institution that administered the mediation. Electronic form included, online dispute resolution, which is just exploding. Enforcement. Each party of the convention shall enforce a settlement agreement in accordance with its rules of procedure and under the conditions laid down in the convention. Refusal to enforce the agreement. If it is proved that a party was under some incapacity, or the agreement is contrary to the law that should govern it, or the mediator did not comply with standards of the proceeding, or the agreement has already been approved by a court. There are a lot of concerns about the interpretation of these rules. According to many practitioners, the enforcement should not be necessary because the party usually comply with the settlement once it's reached. Moreover, among the LCM principles, agreements must be recorded in writing, signed by the parties and the mediator. However, because of the confidentiality of the mediation proceeding, many mediators conscientiously may refuse to sign a settlement agreement. It should be kept in mind that at the end of the mediation procedure, if an agreement is reached, there are two documents: the text of the agreement signed by the parties and a minute certifying the mediation was performed, signed by the parties, the lawyers, and the mediator. Also, an agreement could be enforceable if the parties furnish proof that there was a serious breach by the mediator of standards applicable to the mediation. But up to now, there are no mediation standards shared at international level. Article 4.2, the requirement that a settlement agreement shall be signed by the parties or, where applicable, the mediator is met in relation to an electronic communication if a method is used to identify the parties or the mediator and to indicate the parties or the mediator intention in respect of the information contained in the electronic communication, and the method used is either as reliable as appropriate for the purpose for which the electronic communication was generated or communicated, in the light of all the circumstances, including any relevant agreement, or proven in fact to have fulfilled the function described in paragraph A above, by itself or together with further evidence. But up to now, there are no agreements on electronic signature shared at the international level. Many countries are working on it, also the European Union. Article 5.1. The competent authority of the party to the convention where relief is sought may refuse to grant relief at the request of the party against whom the relief is sought, only if the party furnishes to the competent authority proof that the settlement agreement is null and void, inoperative or incapable of being performed under the law to which the parties have validly subjected it, or, failing any indication thereon, under the law deemed applicable by the competent authority of the party to the convention where relief is sought. Article 5.2. The competent authority of the party to the convention where relief is sought may also refuse to grant relief if it finds that granting relief would be contrary to the public policy of the party, or the subject matter of the dispute is not capable of settlement by mediation under law of that party. In my opinion, The main concerns in the application of the LCM are the following. Enforceability could change the real nature of mediation, making it adversarial. What is happening in Italy? Most lawyers will shift from arbitration to mediation, but they will continue using the same techniques. It will not easy at all to realize a common standard of conduct for mediators and mediation, given the huge differences in cultures and in ADR techniques in different states and continents. What to do? Mediation is not a panacea for dispute resolutions. Enforceability may be a chimera. The LCM is just a starting point of a very long way to go. As mentioned above, there are four main ways to solve conflicts: negotiation, mediation, arbitration, litigation. It is necessary to choose the most adequate one based on the circumstances. If the parties live in countries where there are enforcement difficulties, a local court decision could be the best choice. If it is necessary to interpret standard rules with prevailing legal aspects, which will be included in future contracts, an arbitration aware will be the second best. If time is money and the long-term well-established trade relationship has to be continued, mediation could be the only way to go. And different issues have to be considered in order to get an efficient cross-border mediation, such as mediation contract clauses, proceedings, freelance professional, mediation institution, mediation co-mediation, cultural difference, and training. Hybrid clauses, med-R opt-out, med-R diff recommendation, not binding med-R, etc., are used in many countries, mainly to save time and money, or to enforce the mediation agreement through an arbitral award. And also, mediator and arbitrator are the same profession in many proceedings. As a result, mediation will lose confidentiality, and the parties will be careful not to open up for fear that what they say may be used against them in the subsequent arbitration or judgment. The LCM avoids this problem because the mediation agreement will be enforceable by itself, and an adequate use of the mixed mode dispute resolution will be possible, provided that mediator is a mediator and arbitrator is an arbitrator, two different professionals. The enforceability may be a chimera too. The foreign arbitral aware mediation agreement must be recognized by a court. The judgment must be executed in the by the local authority, and recoverable assets are needed. All three conditions may not always occur. The LCM will not be the panacea for international commercial mediation. It is just a very important initial step of a very long way to go. The LCM is an international convention, and its success in the long term will depend on the number of ratifying countries. And I think that we are in the right way. As mentioned above, in 2019, 46 countries signed the convention. In May 8, 2023, 56 signatory countries, 11 ratifying countries, among which Kazakhstan, Qatar, Saudi Arabia, Singapore, and Turkey. United Kingdom of Great Britain and Northern Ireland signed the convention on May 3, and it seems willing to ratify it in not a long time. Main problem: it's very likely that many lawyers attending or managing the mediation proceeding, we use the techniques, the mentality of arbitration. In other words, the lawyerization of mediation. What's happening in Italy? Let's revert to the question raised at the beginning. A Portuguese maritime operator has a branch office in Singapore, which has a dispute with a customer in Saudi Arabia. How to deal with a problem? If the branch is legally based in Singapore, it will be able to resort to the LCM, as Singapore and Saudi Arabia have already signed it. And good luck. It's a very complicated matter.
But again, thank you very much, Giovanni. It's you started with a case and you solved the case. Sometimes it's not that that simple, right? But in this situation, you really explain how to be able in a specific situation to resort to the Singapore Convention nowadays.
It's a very long way to go, but the best means just to solve the problem, to try to make a better solution, is training.
Yeah, indeed.
Really deep training.
Indeed,
possibly with other countries, based not only on theory of mediation, but also on practice of mediation in other countries. Because in South Asia, they use mediation, international treaties, much more than in Western countries.
Indeed.
They have a completely different cultural approach.
It's true. It's true. We have had this experience also brought to us over our workshops, and it's a good playing field for to understand how mediation could be further promoted. I've also been participating on discussions on the Singapore Convention in South America, which could also be another area where the Singapore Convention could indeed have be established in Brazil, Peru, and many other countries. They are discussing.
But try Hong Kong, Singapore, countries like this.
No.
And you will see the difference.
I'm just thinking of widespreading it, right? I think that maybe the biggest problem now, starting with the debate part.
But it's possible just to raise to organize an international master funded by the Erasmus Plus funds. Also connected with the Horizon funds, because of the online dispute resolution and all the techniques made on the OER, you know. So as a university, you could try to organize this master international, but not only among the university teachers, but also with operating people.
Well, we
okay.
Well, specifically on the Singapore Convention and on enforcement of mediation settlements, we haven't been thinking of that, but it's a good idea. Thank you, Giovanni. In this case, we try to do both things with maritime mediation.
Both Erasmus Plus and Horizon.
I know.
All connected.
I know. Thank you very much for the idea. I don't know, Carlo, we have to think of this. I know there are some programs already established.
It is a huge opportunity, because after the signature by UK, many countries will just think, just going the same way.
Will follow. I understand.
Well, let's go on. Any question?
That's the idea. Does anyone have any question? No, but maybe I will start with oh, Carlo, thank you. Both, it goes both ways. You talk and you ask. That's wonderful. Please.
I want to exploit having the opportunity to speak with Giovanni. And I was thinking of more than a question, comment he might have to a specific comment, a specific topic around mediation. The premise is that, at least in shipping, we are all obsessed about artificial intelligence these days. We see artificial intelligence coming from everywhere. Giovanni is stopping me already. He knows where I'm going.
Is step by step, please, because artificial intelligence is a completely new word. I do not anything about artificial intelligence.
No, but my question is,
well, it's
not
okay.
about artificial intelligence per se. It's coming. I mean, it's coming everywhere. I don't know if you guys have tried ChatGPT, but you know, ultimately they might change the academic world too. In our sector in shipping is changing the way we think about the vessels in the future, etc., etc. In the trials, in the procedural trials, there is a scenario where the artificial intelligence might completely substitute the role of the judge. You can make a judgment through an artificial intelligence algorithm in 5 minutes. The time a judge needs to read the argument, the counter argument, the pleadings, the witness, an algorithm can do in 5 minutes. Forget about the timing in court, which is one of the reasons why we go to alternative dispute method, because the courts are too.
I am horrified, terrified by his words. Just a judge can be a substitute. Go on.
No.
Sorry.
And that was the first comment. And the second comment is that people might stretch this argument, saying that even mediator might be replaced by an algorithm, which for me is completely out of mind. But there are some theories out there that say that at one point, even the mediator with an algorithm can tell you which are the pros and cons. But to my experience, my practical experience in a mediation room, I need a person on the other side to look in the eyes, to tell me what is wrong and what is right, and to guide me through a settlement in the end. I wanted just to share this comment with you and know if you had any,
Thank you, Carlo.
Well, you told a very important word, just look in the eyes.
Yeah. And share your tie. Carlo. Always bring a tie to the table.
Exactly.
So
I always bring an extra one.
We would like, maybe we could use ties.
There was a funny and real fact, and the guy was very happy. He took the tie. And
you can just start that. It's really, I loved it. I love the. Well, but I just want to say that we have here, as I said in the beginning, we have here Guilherme. He's working on mediation and international artificial, well, also international, very international artificial intelligence. So maybe I give a bit the floor to Guilherme, because I think from all of us here and for what I know, he's the person that has devoted lots of thought to the issue. So Guilherme, could you just comment on
very interesting article, but unfortunately written in Portuguese and not in English. It's okay. Go on.
He will translate it through, I don't know, DeepL or ChatGPT. Don't worry. He will send it to you through one of these platforms. Guilherme, please.
You, Professor.
Very, very low. Your sound is very low.
Yes, I think I put my microphone very low because it's a lot of sound here in my neighborhood.
Now we hear you well.
Yes, okay. Well, it's a pleasure to be here. Thank you, Dr. Dulce Lopes.
Roberta is saying no. What are you saying, Roberta? You cannot hear?
No.
A little bit higher, can you? Or just scream.
Hello? I will try to turn off the earring. Maybe it's something that...
Okay, we'll wait for a little.
Yeah, thank you.
Okay, now can you hear me? Yes. Okay. So the problem was
perfect now.
was already discovered. Well, thank you very much for this opportunity. It was a pleasure to hear Dr. Carlo Corcione and Professor Giovanni Matteucci. I really agree with you, and I told during my workshop that I don't believe that artificial intelligence may replace mediators. I think that they be a very powerful and useful tool. And especially, it was the part that I loved in the presentation of Professor Corcione at the case assessment, because, and I totally agree that sometimes people go to arbitration and only during the arbitration they make a correct scenario, they make the case assessment correctly, so it is useful for the mediation later. And I think that artificial intelligence can be used as a powerful tool to help mediators to make that analysis of the case and show the parties. Have you ever saw that risk? Do you have this pro or this con in mind? So the artificial intelligence can help with finding information and processing it. But I really agree with both of you that we still have to be a human being trying to liaise and link the other two parties. I totally agree with you. And I would like to take this opportunity to make a very small question. May I, Dr. Ducey? It was at the end of the presentation when you were talking about closing documents. I had some experiences, and I would like to see if you can share your experience too. During this closing documents, sometimes it's another mediation process because, as you said, you give a tie and you settle that the amount is 2,500,000, and then we are writing down and some parties say, well, but I cannot wire to Saudi Arabia. No, my company have problems with that. So try to fix some installments that were not previously established when you make the big deal, and then you go on details, tax aspects of different countries. If you can help, I think also artificial intelligence may help to find the best track to follow in those closing moments. And I think I would like to hear a little bit about Professor Corcione and Professor Matteucci about that, if they have this experience in their mediations. Thank you very much once again for the opportunity. It was a pleasure.
Thank you, Guilherme. From my side, they say devils is in details, or as I said, you know, the trick actually is in the execution of things. So once you have a plan, even if it's a closing plan for a mediation, then executing that is the most difficult part. To tell you the truth, I think one of the best deal I made, it was not a mediation in court, it was a private negotiation. I think it was the best deal I've reached in my life. It didn't go through because of a detail in the contract. So we were all happy, we closed, it was a Japanese counterpart. We were all happy, we even went for dinner to celebrate with the other party after that. We went back home, documents were sent, deal off for one clause in the contract sent by the other party. It was a sentence actually that could not be accepted because he had an impact on the structure of the company. So deal off. So what you said is actually totally right. And I'll make sure my next presentation of mediation will include this detail, because once you think it's over, it's just started. So thank you. I don't know if Giovanni wants to add something.
I just wanted to say, artificial intelligence will change our lives, that's sure. But please, step by step, international commercial mediation. First of all, we still do not have common share rules. We still not have international standards on the online dispute resolutions. and there are huge cultural differences. And if we do not start from a common training, not only on theory, but also on practice, it will be very, very difficult just to achieve a shared way of using mediation. Otherwise, just mediation will be the next arbitration. And the problem of the lawyerization of mediation is already started in USA 10, 15 years ago. Well, USA started in the contemporary world to use mediation quite a lot at the end of the century. But now they are experiencing the lawyerization of mediation. There is a very interesting article by Norma Hawley, written in 2010, Arbitration, the New Arbitration. And so you are a professor, teacher, you have the possibility just to organize something very interesting, international training, but not only on theory, but also in practice. And there is the money. That's all. Very important.
I think we have to discuss further on that.
When I know this opportunity, I was a banker. My job was to find and to give money. Well, I always know that if you want to organize something, you need money. And European Union gives the money just to make something like this. That's all.
It's true. We are benefiting from international projects at this point.
May I?
Sim, Roberta.
Like 2 very quick questions. And it's more an opinion question. For Giovanni, like why do you think the European Union hasn't signed the Singapore Convention? And for Carlo, how do you think we spread out more the use of mediation on the shipping industry? And why do you think it hasn't been more widely used?
It's a very professional word. There are very few people in the world that manage just the contacts and just these conflicts. And so then there are some universities, 2 universities, I think, in Europe that are just focusing only on maritime international mediation. And I think that they got many articles or many studies about this. In Italy, I couldn't find almost nothing. Well, there is the University of Bologna, just at the siege of Rimini, and Carlo, please correct me if I'm wrong, that now started just a master on this subject. But we are just really at the beginning. A few lawyers merge these topics. But you get in touch with these 2 universities. I think one is in Amsterdam, if I remember well. I think they should have many articles and many studies about this subject. Maybe that Carlo will know more about it. Also, Guillermo. Let's go on the clauses, if you agree. Okay, the mediation clauses. Mediation contract clauses. Mediation contract clauses are more and more present in commercial maritime contracts, also reflecting the spread of hybrid dispute resolution procedures outside the courts. Mediation and arbitration interconnected in various ways. Let's have a look at the BINCON, Baltic International Maritime Council, Mediation Alternative Dispute Resolution Standard Clause, developed in 2021. In view of the significant time and costs associated with court and arbitration proceedings, BINCONs have developed a standard clause of inclusion in chartered parties and other contracts, which makes it possible for the parties to solve disputes via alternative dispute resolution, and in particular mediation, early neutral evaluation, and early intervention. To be used together with the Bingham Law and Arbitration Clause 2020 or any other law or arbitration jurisdiction clause not in place of it. I repeat, to be used together with the Bingham Law and Arbitration Clause 2020 or any other law and arbitration jurisdiction clause not in place of it. In other words, hybrid procedures. In the event of a dispute or difference arising under, out, or of, or in connection with this contract, either party may at any time, either prior or subsequent to the commencement of any proceedings, invite the other to participate in an alternative dispute resolution procedure, including, but not limited to, mediation, early neutral evaluation, and/or early intervention by written notice to the other party. The other party shall, within 14 calendar days of receipt of such notice, replies in writing, either agreeing to participate or declining to participate, giving reasons for declining. If the parties agree to participate in ADR procedure, they shall both take such steps as are necessary to progress the ADR procedure in good faith and without undue delay. The parties' participation in the ADR procedure shall not affect the rights of either party to seek such relief or take such steps as it considers necessary to protect its interests. Subject to subclause J, the ADR procedure shall be without prejudice and confidential, and no information or document disclosed during it shall be revealed to any tribunal and/or court in any subsequent or ongoing proceedings, except to the extent that they are disclosable under the law and procedure governing the relevant proceedings. Unless otherwise agreed, each party shall bear its own costs incurred in the ADR procedure, and the parties shall share equally any third-party costs and expenses. If the other party does not agree to participate in any ADR procedure under this clause, that fact may be brought to the attention of the competent tribunal and may be taken into account by such tribunal and/or court when allocating the costs of the proceedings as between the parties. The parties should be aware that the ADR process may not interrupt time limits. All these problems, believe me, just we are facing them in Italy with the new laws of mediation just approved a few months ago. Bingham explanatory notes. Forms of ADR are being used worldwide, but with different names and different procedures. Before, commonly used forms of ADR are mediation, early neutral evaluation, and early intervention. These forms of ADR are intended to facilitate the prompt and amicable solution of disputes between parties, allowing them to preserve their commercial relationship and to operate sensibly their commercial contracts, and to help them avoid arbitration and court proceedings, which can be protracted, costly, and commercially disruptive. Mindful of the importance of developing the clause that has broad application, the clause is not limited to any one of the different forms of ADR. The clause has been drafted as an all-encompassing ADR clause, but the title has maintained the reference to mediation for familiarity. The clause allows for traditional mediation, where the party sits in one room or video conference with the aim to settle the dispute during that meeting. This is a relatively formal process and often takes place at quite a late stage of a dispute when proceedings are already on foot. In early notarial evaluation, an independent and impartial evaluator is appointed to provide the parties to a dispute with an assessment of the merits of their case. The objective of an early note evaluation is to give parties a realistic indication of the merits of their respective cases, to help inform the negotiations between them, and, if the evaluator considers it appropriate, to put forward a figure or range for settlement. The parties should consider the nature of the claim, guidance required, and their relationship status before they decide on the ADR form to be used for solving their disputes. Parties can refer the dispute to one of the ADR methods at any stage before arbitration is commenced or during the arbitration proceedings. During arbitration proceedings, under the law of the primary venues where maritime disputes are resolved, there are no procedural differences between the ADR forms before or after legal proceedings have been commenced. The ADR procedure can be conducted by mediators and evaluators who will have procedures rules in place. This is the problem, to have the procedures rules in place. Providers can be found in all the major venues. The clause is intended to replace the Banco Mediation Clause 2020. The mediation clause has not found great acceptance in the market and not much used. There is an increased interest worldwide, and Banco believes that by developing a new clause dealing, in principle, with all types of ADR and promoting it widely, this will further encourage the use of ADR as an alternative to other more expensive and time-consuming dispute resolution methods. The clause must be used together with the Banking Law and Arbitration Clause 2020, together, or any other law and arbitration jurisdiction clause chosen by the parties, because it is not replacing a law and the jurisdiction clause, which is a vital part of the contract. The Banco Mediation Alternative Dispute Resolution Clause can be used in any jurisdiction agreed in the governing contract. This is important to note if the contract is governed by USA law, as arbitration is considered as alternative dispute resolution. These hybrid procedures allow for more flexibility and enable outcomes better suited to the needs of traders, provided that mediation and arbitration are managed not by a single professional, but by a mediator and an arbitrator, each different from the other. Many times in India, in Southeast Asia, usually there is only one professional managing mediator and mediation and arbitration, unfortunately. Therefore, mediation, arbitration may have that mediator and arbitrator are different persons. ARB, MET, ARB. These are the different kind of procedures. And the ARB, MET, ARB, they started using in Singapore, if I remember well, in 2004, just to have the enforceability of the mediation agreement. In many countries, mainly in Asia, MED-ARB, the same person acts as an arbitrator and arbitrator, unfortunately. MED-ARB, diff recommendation. The mediator and arbitrator are different persons, but if the participant failed to reach a voluntary agreement during the mediation phase, the mediator makes a recommendation to the arbitrator, who is a different person. Non-binding MED-ARB, mediator and arbitrator are the same person. The neutral first acts as a mediator, but if the participants reach impasse, then provides them with a non-binding opinion. This model is very similar to the evaluatory node of mediation. made up another clause, made up show clause. Mediator and arbitrator are the same person, but the person renders only a tentative decision with an order to show cause. Why? It should not become final. If the participant can demonstrate flaws in the decision, the mediator arbitrator will correct the decision. Media law. The participant first attempt voluntary settlement through mediation, but if they reach impasse, then they submit their final offers to an appointed arbitrator who is limited to adopting one of the parties' final offers in the award. Still again, the hybrid procedures allow for more flexibility, but I strongly recommend the mediator and the arbitrator must be two different. Otherwise, parties during the mediation procedure will not reveal the real problems beneath the conflicts, for fear that what they reveal may be used against them at the arbitration stage, in this way deeply undermining the potential of mediation. Many thanks for your attention.
Thank you, Giovanni, for this second part of the presentation. We didn't realize you had the second part because you took off the sharing of the screen, but it was a good compliment to the first, so we thank you. I would like just to ask, at this point, first I would like just to still go back to the questions of Roberta that weren't totally answered. And I would like to give a bit of my point on why doesn't the EU sign and ratify the Singapore Convention. Well, I believe also, as Giovanni says, this is a matter of also the development of mediation in Europe, but also the fact that under the directive, the terms of enforcement of mediation agreements are very dissimilar. They allow everything: homologation by courts, public notary deeds, or direct enforcement. In Portugal, we went for the direct enforcement under certain conditions, but this is not the widespread option of many of the European countries so far. So this means that if you internally do not accept direct enforcement in courts of mediation settlements, then probably you will not be bound internationally by the Singapore Convention that provides for an immediate enforcement and execution, although they use other words for this. So I think this is one of the reasons, maybe, I don't know, Carlo, if you agree, and if you want to answer this question, and also the second question of Roberta. If you don't remember, she will she will repeat it.
To the question of Roberta, if I got it right, it was why mediation is still not mostly used, sort of.
Yeah, how to make it more like more used, widespread it.
Let me give you the most brutal question I might have, because litigation is a business, and we make more money litigating than mediating, to be honest with you. And people want to litigate, and then at one point, after they have squeezed the clients, they start to mediate. I think this is one of the main reasons, especially in shipping. Litigation and legal is a proper business, it's a business itself, and sometimes even lead the proper business. Thank you, Giovanni, for agreeing with me. And then there is a second point, which is a little bit more, I think, practical from my experience, that mediation is quite difficult to be reached because people need to take the risk during mediation to accept a settlement. And we are going towards a world where people are afraid of responsibility and they want simply to follow a protocol. I'm following a protocol, especially if you deal with big companies, big corporations. I work a lot with the oil industry. In the oil industry, it's very difficult to find someone from BP, Shell, as I said before, Petrobras or whatever, entering into a room and accepting a settlement for 50% of the best case scenario for his company. Because if things goes wrong for some reason, or if at one point someone turned up in a boardroom saying you made a mistake because we could have won, you know, 3 times more, that person might lose the job. I think that's another very commercial aspect of mediation that is getting more and more complicated. Governments are going towards to be more and more structured, and people are afraid to settle, essentially.
Thank you very, very much. Oh, and thank you both, because I didn't have the opportunity to thank you before for being here. This was even better than we had planned.
Yes, that is true. So, but does anyone have another question? We already debated in the middle. Does anyone want to debate a little bit?
I have not a question, but I'd like to ask Giovanni, since I see one of my PhD researcher from Turkey, Damla is about to research on a paper on mediation in shipping based on the UK signature on the Singapore Convention. So I'd like Giovanni to share, if possible, with us the slides and perhaps other material that he might have, because it will be beneficial for Damla's research, please.
Many thanks. Of course, I share the slides. And also, I share a link to an article of mine about the evolution of mediation in Italy in the last 11 years. And Italy is really a case study about why mediation is not appreciated by many people, because, as Carlo told, of money. Even if there is a very long history in the legal culture of Italy of mediation, and how the compulsory of mediation and the enforceability of it is just changing its nature. So I share my slides and also my article. If we'll be in touch about what's happening in Portugal, it will be very interesting in getting news.
Yes,
Because other countries are just studying the Italian model. And I would like just to know, French now is doing something. Germany, they got courses that reach a solution just 9 months, so they don't need mediation much more. But what I always underline, training. I got in touch with mediation in 25, when in Italy nobody talked about mediation. Just attending a master degree of 164 hours. Now in Italy, just to become a mediator, you need to attend a beginning training period of 50 hours. It's just the consequences have been terrible, because lawyers know how to manage a conflict in courts, and they remember these rules, this way of managing the situation, just using them to the mediation, which is the lawyerization of mediation. So you are teachers, please, training, deep training is extremely important.
May I suggest you put your emails in the chat, and I'll ask Giovanni and Carlo to send us the.
Allora, in chat okay.
I'm gonna write one message here.
Okay.
For everyone.
In chat.
Yes, please. So I can all of them, and then I'll send.
I try
to everyone that is here. I think that might be easier.
Unfortunately, And if I'm not experienced at all,
Your email,
as you can see.
yours is easier for me to get because we're in touch.
Now the chat figure disappeared completely. Oh, well. I send you through LinkedIn or through email, and you will share them to the other people just here. Okay.
Thank you.
I have Carlos. I have.
Thank you.
I have.
I sent you my both
Guilherme.
professional and personal. Let me add just a very quick thing on what Giovanni said about training students. I often arbitrate the moot competition on arbitration, the one arranged by the university in Australia, the Queensland University in Australia. And I find it's very, very useful for students. And actually, some of the students are already lawyers. I mean, they are really, really good. And I think moot competition on mediation should be put forward to train young students. Thank you very much, everyone. Thank you.
Thank you, Carlos.
Thank you.
I succeeded in sharing the slides.
Thank you, Giovanni.
Have you got them?
Thank you.
Thank you.
Wait.
Okay, so there was a confirmation that the slides were sent. Well, I thank you all for the presentations and for the lively debate. We will continue with our Medimare project until the middle of July. We will have still an intensive course that will be an educational and training program on maritime mediation that will take place in Leiria with 54 hours with both theoretical and practical classes, as Giovanni so prompted that we should have. And on the 30th and 1st of July, we will have a final symposium on these issues. There is an international call for papers open. So Carlo, for your students, if you wish, there is an international call for papers that they can be presented hybridly, so in a hybrid format. So
I sent it. I already sent it to him.
Okay.
Yesterday, I think, right?
And then we will continue working, and maybe, who knows, a project will come from here, as Giovanni tried us to very, very almost forcibly start to do it. So let's keep in touch. It was a pleasure, and see you in the intensive course and in the final symposium. Bye, everyone. Thank you.
Thank you very much. Thanks.
Thank you so much.
Thank you.
Bye.